Did the Supreme Court just nullify more than 3 million Virginia votes? That's the viral headline, and the uncomfortable answer is, in practical effect, yes. But legally, the real story is not so dramatic. It's stranger, more procedural, and probably more important. The internet's simplest explanation, and it's everywhere, is Republicans are out to get us, and courts are helping them do it. But that theory skips over the actual legal machinery that decided this case. And before we go any further, here's why you should listen. I'm not a political influencer parachuting into election law because a headline went viral. I'm a constitutional litigator. I'm active in federal courts across the nation. I work on live constitutional controversies, and this is the kind of terrain I actually practice in. So if you want a red meat outrage monologue, there's plenty of strip mall legal analysts online who will happily sell you one. But if you want no-nonsense, low-drama constitutional analysis, stick around. So the backdrop. Virginians voted on a redistricting referendum. It passed 1.6 million to 1.499 million. Then Virginia's highest court said the whole thing was legally void. A week later, the U.S. Supreme Court refused to rescue it. So if you're looking for a dramatic hook, there it is. 3 million votes went into the machine and no new congressional map came out. So for voting rights, here's the part almost everyone online is mingling. This was not the U.S. Supreme Court announcing Virginia voters are props in a democracy play. It was not a grand D.C. opinion saying elections do not matter. The decisive move came from the Virginia Supreme Court, which said Virginia Democrats broke the state's constitution's amendment process before the referendum ever became legally effective. The Supreme Court then issued a one-line emergency order saying essentially, we're not jumping in right now. Tiny civics reminder. Courts are supposed to be anti-democratic. Not anti-democratic as in we hate voters, but anti-democratic as in the majority still has to follow the rule book. That's kind of their whole point. So here's the timeline without the lawyer fog machine. In 2020, Virginia voters created a bipartisan redistricting commission. The commission deadlocked, so the Virginia Supreme Court drew the current 2021 congressional map. Then Democrats came back with a temporary amendment to allow a new mid-decade map for 2026. Voters approved it. The Virginia Supreme Court killed it. The Supreme Court refused to revive it. Why? Because Virginia has a very specific rule for changing its constitution. You do not just pass an amendment once, put it on the ballot, and call it a day. The legislature has to approve it. Then voters have to elect a new House of Delegates. Then the legislature has to approve it again, and only then does the referendum happen. Virginia built a waiting period into the process. The court said Democrats botched that waiting period. Early voting in the House of Delegates had already started on September 19th. The legislature did not first approve the amendment until October 31st. By then, more than 1.3 million people had already voted. So the majority said, you cannot count that election as the constitutionally required election in between if a huge chunk of voters had already cast ballots before the amendment was even on the table. That's the whole technical fight. Not fake ballots, not secret corruption, a timing rule, a brutal one, but still it's a timing rule. So you can absolutely think that reasoning is too cute by half. The dissent said the majority stretched the word election to include weeks of early voting, even though state and federal election law often treat election day as the actual endpoint that counts legally. It's a fair critique. But notice what kind of fight that is. This is not a, we found a secret suitcase of fake ballots behind a Denny's. This is judges honestly arguing about how a state constitution sequences amendment steps in an era of widespread early voting. And this is where a little humility helps. Before we shout corruption, we should at least ask whether we actually understand the machinery being argued over. Outrage is easy. It feels clarifying. It gives us a villain, a team, and a dopamine hit. But it can also make us dumber. Sometimes the harder, better move is to say, I don't like this result, but I need to understand the rule before I decide the rule was rigged. Hopefully I can help with that process. Timing was not the only problem lurking in the background. In the emergency papers at SCOTUS, respondents said a separate injunction in another Virginia case rested on 6 additional state law grounds, including allegedly misleading ballot language. That matters because even if you thought the Virginia Supreme Court's timing analysis was wrong, applicants still faced a pile of state law obstacles. And that is one reason the emergency appeal was such a long shot. There was no clean, single federal silver bullet waiting in the wings. There was a thicket. Election lawyers love a thicket. So why did the Supreme Court say no? The honest answer is we do not have an opinion explaining why, because the order was one line. But the strongest explanation is the oldest one. The U.S. Supreme Court usually does not second-guess a state court on a question of state constitutional procedure if the judgment can stand on state law alone. Respondents told the court exactly that, arguing this was a Virginia amendment process case dressed in federal election clothing. In plain English, this is the adequate and independent state grounds idea. If the state law reason is enough to keep the judgment standing, even after you strip away the federal arguments, the Supreme Court usually has no good reason to play superhero on the emergency docket. This is also where people mash together RUCO v. Common Cause, Moore v. Harper, and the independent state legislature theory into one big legal smoothie. Don't do that. RUCO said federal courts cannot referee pure partisan gerrymandering under the federal constitution because there's no workable federal standard. It also said state constitutions and state laws can still provide rules for state courts. Then Moore rejected a strong version of the independent state legislature theory and said state courts can apply ordinary state constitutional review to federal election laws. The lesson is, federal courts often stay out of partisan fairness fights while state courts still police state constitutional process. And now the Louisiana comparison, because this is where half the internet faceplants. Louisiana is a federal racial gerrymandering case. In Louisiana v. Calais, the court tackled this question whether compliance with Section 2 of the Voting Rights Act can itself count as a compelling interest that justifies race-predominant districting under strict scrutiny. The court said no. That's a federal equal protection and Voting Rights Act collision. Virginia is the opposite animal. Virginia asks whether the state ever validly completed its own amendment process under Virginia's constitution. One is federal home turf for the Supreme Court. The other is a state law maze with federal court exit signs all over the place. The other reason the emergency appeal was weak is the modern emergency rule, sometimes called the Purcell principle. Federal courts should be very wary of changing election rules late because that creates confusion and administrative chaos. The Virginia order did not explicitly cite Purcell, but the broader pattern is unmistakable. In RNC v. DNC, the court said lower federal courts should ordinarily not alter election rules on the eve of an election. In Merrill v. Milligan, it stayed a lower court Alabama map order. In Robinson v. Calais, it expressly cited Purcell to freeze a Louisiana federal injunction. In Abbott v. Lulac, it faulted a district court for intruding into an active primary campaign. Translation: when judges are asked to scramble election machinery under time pressure, this court usually reaches for the brake pedal, not the nitro button. Let's get back to the real world. Practically, this case is a big deal for the House. Reuters and AP reported that Democrats wanted the Virginia map because it was designed to create 4 real pickup opportunities from Republican-held seats. The Public Cook report tracker likewise labels Virginia as a case where the state court erased potential Democratic gains. And this matters because the House is tight. It appears Democrats need only 3 seats to win a House majority, while another Reuters analysis says Republicans may gain to up to 12 seats overall through this mid-decade redistricting wave, and that Democrats likely must win the national House vote by roughly 3 to 4 points to overcome the map advantage. So when Virginia drops out as a 4-seat Democratic counterpunch, that's not a side quest. That's national scoreboard territory. And that's why the reactions were so apocalyptic. Governor Abigail Spanberger said in substance that more than 3 million Virginians had made their voices heard and that the ruling was a profound disappointment. The reactions are politically predictable, but the legal reality is still the same. This was a fight over sequencing rules, not a proven scheme of hidden corruption. If you treat every procedural loss as evidence of cartoon villainy, you stop teaching people how power actually works. And in election law process, think about it. The meta rules, that's where power resides. That's why humility is not weakness here. It is intellectual discipline. The noble response to a hard election law ruling is not to instantly translate my side lost into the system is criminal or it's rigged. Maybe the court was wrong. Maybe a dissent has the better argument. Maybe the rule should be changed. But those are different claims from corruption. A serious person should be able to hold that distinction in his head for more than 5 seconds. What does all this mean? The Constitution's not a vending machine. You do not just insert 3.1 million votes and get a new map to drop out of it if one of the internal gears was never lawfully set. That can feel anti-democratic. It can even be worth criticizing on the merits. But it's still different from the corrupt villains movie narrative trending online this last week. This case is less smoking gun and more constitutional plumbing diagram. Virginia's highest court said the pipe was installed wrong. Not that votes don't count, not that somebody in a cloak stole democracy at midnight. The court said the legal pipe carrying those votes into a valid constitutional amendment had a defect in it. And when Democrats asked the Supreme Court to rush in, tear open the wall, and reroute the system before 2026, the court declined to send the emergency plumber. That's maddening if you like the referendum result. It is politically enormous if you care who controls the House. But it's not the same thing as corruption. The real lesson is that election law is not just about who gets more votes at the end. It's also about whether the legal machinery that turns those votes into binding power was built correctly at the beginning. Process is not decorative. Procedure is not paperwork for nerds. In election law, procedure decides who draws the map. The map decides which seats are competitive, and those seats may decide who controls Congress. So yes, this story starts with 3 million votes. But it is not a case about corruption at the Supreme Court, or about democracy being stolen by cartoon villains in robes. It's a case about something less cinematic and much more important: how votes become law. In election law, the boring rules are often where power lives. They decide whether a referendum counts, whether a map becomes valid, whether 4 House seats are suddenly in play, and maybe, in a close year, whether Congress changes hands. That is why this matters. Not because every procedural ruling is noble, not because courts are always right, not because voters should shrug when their preferred result disappears, but because if you do not understand the machinery, you cannot tell the difference between a rigged system and a system enforcing rules you didn't know existed. And that's the distinction between being outraged and being informed.